Hi again, everyone. Bob Burg with another episode of Go Giver Influencers. Very special guest today. This is going to be a lot of fun. Our episode is titled Courtroom Influence. And, you know, it reminds me that of the many times I've been summoned for jury duty, only twice have I actually gotten called up into the main courtroom or one of the courtrooms for voir dire, which if you've watched even one or two rerun episodes of Law and Order or any of the courtroom dramas, you know that that's where the attorneys from both sides, the prosecution, the defense, or the litigating plaintiff, or the defendant's attorney, they size up the jury pool, basically to see, based on certain criteria, I guess, whether you're more likely or less likely to vote their way. They're sizing people up. But here's what I also noticed, and I checked this out with some of my other potential jurors, that while they're checking us out, we're checking them out. And we're kind of wondering, hey, are they a nice person? Are they honest? Are they really seeking the truth? Now, it makes sense logically that we'd wonder if they're honest, of course, because we want to know that someone is presenting looking for truth, of course. But you know what's not very logical? That we really care if they're a nice person. Because when you think about it, it should be that all we're interested in is the facts, right? I mean, we've got a person in a criminal trial, someone's liberty at stake. In a civil trial, maybe a judgment that's going to put a company out of business, or maybe leave a family who's been hurt with no recourse financially. So it should really come down to logically just what's the truth. But we know as human beings, we are emotional creatures, and we make decisions most emotionally. And most of the time we do this, we're not even aware of it. And we would swear up and down that our decision was absolutely, totally logical. So this is kind of dangerous when you think about it. I mean, should the personality or persuasiveness of the attorney, should their ability to influence play that big a role? Well, maybe it shouldn't, maybe it should, but I suspect it does. Well, our today's guest can certainly clarify my hypothesis here, because he happens to be one of the very, very best in the business, as well as being a great friend of mine. Mitch Jackson is a 2013 California Litigation Lawyer of the Year, who enjoys combining law, social media, and live streaming to disrupt, to hack, and improve his clients' companies, causes, and professional relationships. In addition to trying cases, Mitch enjoys speaking around the country and sharing communication, marketing, and social media tips. He's an early user. He was a very early user of social media and live video, and in 2017 was named by Mashable as one of the top 50 people to follow on Snapchat, and by the American Bar Association as one of the top 25 legal accounts to follow on Twitter. I mean, this is immense influence right here. Now, Mitch has spoken at the New York, San Francisco, and Los Angeles live video summits. He's also appeared on live video shows with Katie Couric, Anderson Cooper, Seth Godin, Peter Diamandis, and many more. And as he did last year, Mitch will once again be sharing digital marketing tips from the stage at Tony Robbins' Business Mastery event. Mitch's main website is jacksonandwilson.com, and his social media and live video blog, streaming.lawyer.com. Shannon Farabee, who's once again filling in for Kathy, will include those and some of his other URLs in the comments area. Mitch's most recent project is a new book titled, well, it's a soon-to-be new book titled Social Media for Professionals. It's due out at the end of the year, and anything Mitch does is always done with such class, and it's always done in such a wonderful, fantastic way. Welcome, Mitch.
Bob, thank you, sir. It's a pleasure to be with you today. I'm humbled.
Wow.
To be on your show. And it's amazing what you can do when you do something long enough for 32 years, that laundry list of things. It's amazing how it just kind of happens. So it's good to be on your show, and hopefully I can share some communication tips with your audience and share a little different perspective on what works and what doesn't.
Oh, I know you will because I've been seeing you do it for years. So I want to know first, is what I said true? Does the lawyer himself or herself really have that much to do with the outcome of a trial? Or is it really, as we'd like to think it is, in the end, the truth will win out?
I'll tell you what, I think all else being equal, personalities, human to human rapport and engagement in the courtroom, it does make a difference. I mean, that's the reality. Should it? I don't know, but I think that it does, Bob. And in your book, Adversaries and Allies, which is one of my favorite people skill books of all time, you're not paying me to say that, but you know, because we've talked before about this, I will not mentor a young trial lawyer until he or she has read Adversaries and Allies. It's that powerful of a book. But you talk about people skills when it comes to success. You talk about people skills being about 10%, technical skills being about 10%, and people skills being about 90%, to the success equation, right? I think in trial, it's probably more like 60-40, 40% technical, 60% people skills, but it's critically important. And that's been my secret over the last 32 years of trying cases. It's been the people skills.
Well, that 60-40 is still immense when you think about it. When you think about what's on the line.
It's an exciting and exhilarating profession. It's the best decision I ever made, Bob, was deciding to go to law school and practice law. I met my wife in law school, okay? And so it's been a great experience for us. And every single day, there's a new communication challenge. Every single day, there's a new opportunity to improve your communication skills, to improve the way you develop rapport with the jury, or with the judge, or even with opposing counsel. So I just think I'm enjoying every single day of practicing law, and especially with social media and live video like this. All of the things that we do on social, Bob, I take back into the courtroom and I use to pick my jury and try my cases. And it's just been a fun experience. And once again, it's great being on your show.
Okay. Well, thank you. And it's wonderful having you. And I want to look more at that later about how you do this crossover with social media in the courtroom and influence, and because it's really amazing how you do this. So you talked a couple minutes ago, you mentioned the word a challenge, and you talked about how every day's a new challenge. So I've got a challenge for you, Mitch. You walk into a courtroom and your challenge is to influence, to persuade 12 people who, I'm going to say, most of them don't want to be there. They'd rather be at their job. They'd rather be with their family. They may, and I don't mean to be offensive here, there are some people who don't like lawyers, and so they may not even be predisposed to liking lawyers. Okay. And your job is to persuade them that they should be voting your way. That's a challenge. How do you handle that? How do you approach this?
It is a challenge. And I think for me, Bob, it goes back to my experiences growing up at the Saddle and Surrey Guest Ranch in Tucson, Arizona. I grew up on a ranch where we would have people visit us from all over the world for a week and play cowboy. And what I noticed is the success that my mom and dad had at the ranch revolved around preparation. It revolved around being human, interacting with the guest, providing them the experience that they want to experience, as opposed to what my mom and dad thought was important. It was all about the guest. It wasn't about my mom and dad or our family. And the same thing applies, fast forward to today, when it comes to a jury trial or a court trial. My persuasion, my interaction begins out in the parking lot. This is going to surprise a lot of people. Professional speakers watching your show will know what I mean when I say understand what your venue's all about, understand who's in the audience. A lot of lawyers don't do this. It starts where I park my vehicle before court in the morning. I park in the public parking lot, not over where there's private parking for the attorneys and judges. Everyone I'm parking next to when I walk into the courthouse, when I'm standing in line with my client, I do not go through the attorney and judge line. I stand in line with my client because I'm surrounded by potential jurors in my case. I don't know if any of these people are going to be my jurors, but there's a pretty good chance one or two of them will be my jurors. And maybe that will be my jury foreman, the person that helps direct the decision-making process when the case is all done. When I'm walking with my client to the courtroom, in the cafeteria, at lunch, I'm with my client, I'm considerate to my client, I care about my client, and that's where the communication process starts. When we walk into the courtroom, The same approach applies with treating the court staff with respect, with using first names when I can with court staff members, with doing everything we can to prepare not only the case, but on the day of trial, to prepare the relationship building opportunity with that jury so that when they are called into the jury box, and I know that you've been in the jury box and you've answered questions during voir dire, when they're in the jury box, if they've seen me around the courthouse, if they've seen me with my client around the courthouse, they're already starting to feel as though I'm someone who does genuinely care about my client, genuinely care about the court system, and genuinely care about the outcome of the case. So preparation is the first step, I think, when it comes to effectively communicating. And if you're a professional speaker, if you're speaking in front of an audience or making a sales pitch or venture capital pitch, you've got to know who your audience is. What is their why? What are they looking to accomplish? And how can you help get them there? That's my secret when it comes to starting off a jury trial.
So really what you're doing, you're creating that benevolent context for your success with everything you're doing from the very beginning. Go ahead.
Oh, absolutely. And I mean, that means if you've been around the courthouses, what most people will see is lawyers looking down, working on their pleadings, talking to their clients. They're ignoring the jury panel. They're ignoring everything else that's going around them. It's all about them and not about the process of why we're here today. You said something very interesting, and I think you're right. Most people don't like lawyers. So if you can be that lawyer that they can look to as someone that's trying to seek justice, someone that wants to take them by the hand and find a just and fair outcome to a case, they're going to start connecting with you. They're going to start looking at you, and they're going to start listening to your side of the case. And as long as you're straightforward, you're transparent, and you're honest with the facts that you present, that's where the magic happens.
So this is all about building trust. It's building trust with everything you say, everything you do, and really just by who you are throughout the entire process. And it's interesting when you're talking about maybe seeing someone in the parking lot, or they're seeing you. And even if you haven't had an interaction with them, if they see that, you know, you're that decent guy, you held the door open for someone, and by the way, and we're not saying, well, you do this as a way of manipulating people into thinking something you're not. No, you are the type of person who would do that and who does do that, but you're letting them see it. And you're not standing aloof. And I have noticed that when I've gone into courtrooms, that many of the lawyers, it's like they're in their own private club, and they seem very confident. And one of the things I think they don't realize is when you're a, I guess civilian, if that's the word, a non-lawyer, someone who's not around the courtroom a lot, okay? The courtroom is kind of scary. I mean, even if you're not on trial, you go in there and it's sort of, it's intimidating. The lawyers never look intimidated because they look like this is where they live. And they don't often make eye contact with you. They don't often make you feel warm and fuzzy and like, you know what I'm saying? So when you can do that, you've just put yourself, as I like to say, 9 steps ahead of the game in a 10-step game.
You have to understand that everyone sitting in the jury box, they don't want to be there. They want to be home with their families. Like you said, they probably don't like lawyers.
And it's not that I'm saying I don't like lawyers, by the way. I'm just saying we know that that's, you know, lawyers and salespeople,
Sure.
which I am, and what have you. I mean, sometimes the reputation just isn't as we'd like to have it. So it's just a fact of life.
It's recognizing the dynamics of who your audience is. In this case, my audience is the jury. And so if you can create a situation where they start to know, like, and trust you because of what they're observing and maybe what they're listening to, this is before we even start our opening statements, you're already 2 or 3 steps ahead of everyone else in the courtroom. I'm more comfortable in the courtroom, Bob, than pretty much any place else on this planet. Mm-hmm. I mean, to me, it's a situation where I'm in control. I've got a judge watching what's happening. And like I said, all else being equal, which means you're prepared, you know the facts, you know the evidence, you know the rules of law, then the rapport, then the personality, then the human-to-human relationships with your jury. That's what's going to separate you from opposing counsel sitting at the other end of counsel table.
I want to just look over at the comment board for a moment. Barbara Hannon, she wrote, "Fascinating, Bob. Glad I could drop in a universal message here." And I knew that's exactly what you'd be providing. Shannon quoted you, prepare the relationship building opportunity. Preparation is the first step when it comes to effectively communicating. Absolutely. We have Andrew here. Hi, Bob and Shannon, hailing from the Western Wyoming Mountains. Hi, Andrew, and Jenny Q, our good friend of both of us, both of ours. Mitch, she's there. Aniki, Kurt Godlewski from Toledo, Linda Ryan, a whole bunch of great people. Of course, if you have any questions for Mitch, I'm doing my best at multitasking by looking over, and Mitch, everyone who knows me knows when it comes to multitasking, I am not the guy to go to. So, but I do my best, and I'm getting a little bit better at it. Todd Moore, great comment right here, said, when one is most comfortable within their space, they can dominate with experience. You know,
Ooh, I like that. I like that a lot. That's a good one.
And our dear friend, both of our dear friend, Mia Voss, love this conversation. She's a great influencer herself. Mia
sure is. She sure is.
Okay, so you might spend, based on what I imagine, years litigating a case. I mean, I'm sure this happens sometimes where it's years. Does the amount of time you spent with the case itself, this may not be a pertinent question, I'm not sure, but I'm going to give it a try anyway. Does the amount of time you've spent preparing a case or going through it, when you finally are going to get to the jury, does the amount of time you've spent preparing the case itself or being involved in the case itself have anything to do with how you would approach the jurors during voir dire, or is it just, no, you've got a system for doing it, you're going to do the same thing predictably every time? Voir dire, I think is the right way to say it.
It's pronounced voir dire or voir dire. Either way is correct. And I do think that each case is different, depending on who opposing counsel is, depending on who ends up being in the jury box. That dictates how we're going to be trying this particular specific unique case. Okay, it's just like making a particular sales pitch or being in the middle of a negotiation to sell a business. The facts are different in each case. I will tell you that the older the case, the longer I've worked on a case, when I'm picking a jury and conducting voir dire and asking open-ended questions, I want my jury to know that this case my client's been living with this case for the last 2 or 3 years. I want them to know that we're here today because of something that happened that they'll be making a final decision on. And this didn't happen last week, like the television shows we watch on television, where something happens and 45 minutes later, they're done with the case. This is the most important thing in my client's life. That's why we're here. That's why you're sitting here. And I'll do my best not to waste your time. I'll do my best to share what's relevant. And in return, I simply ask that you do your best to weigh the evidence and to render a fair and final decision. So yes, it does all come into play.
Okay, I want to ask a question based on something you just said in that answer. But first, I want to, again, let people know where they can find you. JacksonandWilson.com, just as it's spelled. And I know Shannon's been putting these into the discussion windows. And your social media and live video blog, streaming.lawyer.com. There are also a whole bunch of, you're all over. All the social media. I mean, your presence there is just amazing. Where do you, any place else you want people to go to find you that I have not mentioned?
No. Streaming.lawyer is probably the best place to start for social media, live video content, things like that. Bob, it's just, we've got so much to cover. I want this to be about communication tips and communication skills and not where they can find me on the internet. It doesn't matter. Seriously.
Thank you. Well, and they will find you on this, and when we have the show that comes out, when it comes out on YouTube and the finished version, we'll have all those listed. So I want to make sure people know, because you are an amazing resource and teacher. Chris Strubb, great show, fellas. Thank you, Chris. Okay, so yes. So what you talked about was listening. And I don't know if you even mentioned active listening, but I know that's what you do so well. So how do you do that during voir dire, when you have a person on the stand? I know they say, and I don't know if this is true, Mitch, or if this is just TV stuff, but they say a lawyer should never ask a question unless he knows or that he doesn't already know the answer to. Again, I don't know if that's just TV.
Yeah. You know, it's actually, Bob, that's something that a lot of experienced trial lawyers will tell you, but I can tell you right now, had I followed that advice, I wouldn't have gotten some of my multi-million-dollar verdicts. I have no problem if I'm in the zone asking a question I don't know the answer to, because
okay.
frankly, the answer the witness gives me doesn't really matter. And we can talk about that a little bit more. Okay.
Yeah. Tell us about that. Yeah.
Well, no, what I'm getting at is you have a feel. It's a dance. And when you've got somebody, whether they're a friendly witness or an adverse witness, you kind of learn what buttons to push. And sometimes I don't care what a witness says in his or her response. I just want them to respond.
Mm-hmm.
And then look over and the jury will roll their eyes. But talking about listening, when we're picking a jury, I walk into a room, the case is 2 years old, there's millions of dollars on the line. If it's a civil case, somebody's life's been turned upside down by a distracted driver, for example. And now I've got 12 people that we've never met before that are going to decide whether or not the last 2 or 3 years of our work and what my client's been through, what should happen with the case. And so when we pick a jury, what I do a lot different than most lawyers is I'll ask open-ended questions and then I'll stop talking and just listen. I'll listen to what the jurors are telling me and I'll look at their eyes. I'll look at what the body language is of other jurors while someone's answering that question. And I'll steer back over, Bob, you just listened to Mrs. Jones answer that question. Do you feel the same way? Do you feel that there's too many lawsuits in this country? Do you feel that there's no amount of money damages that can make my client whole? We actually talk about things that most people would probably think, you don't really want to bring up that issue. That's a sensitive topic, tort reform, ambulance chasing, money damages, but you've got to talk about that with your potential jury pool so that you can figure out whether or not the 12 final people who are sitting there will step forward with a fair and impartial verdict.
Well, Mitch, that's very much the same in sales. And you bring up a wonderful point, because people will say, well, don't bring up an objection that they may not have. No, bring up anything that could possibly come up. First of all, it's the right thing to do. But secondly, you want to know now. You want to bring it up. You want to be able to either inoculate or be able to get it out into the open so that because if it's a real objection, it's better to know now.
Look, the general consumer is so misinformed about tort reform, so misinformed about money damages that it allows for a conversation. And if you have an open conversation where I'm speaking from the heart as a lawyer, as opposed to instructing a jury, as most lawyers do, that's where the rapport, the know, like, and trust starts to kick in. Even if we agree to disagree, what I try to get my jurors to do, Bob, is to be kind to people, that being my client, and tough on issues, okay? If they disagree about a particular issue, that's fine, but don't hold that issue against my client as a human being. That's what works really well for us. The other side, Bob, is we always try to ring the bell first. If I know opposing counsel has a smoking gun, whether it's in a document, whether it's a witness, I want to be the first person to bring that up in front of the jury while we're picking the jury or during opening statement, and talk about it, share my thoughts about it, and then move on. If I don't do that, it looks like I'm hiding something, and the other side will gain credibility for being the person to bring that up in front of the jury. So it's strategically transparent, it's speaking from the heart, it's asking open-ended questions, and watching the body language while you're picking your jury.
Okay, let's take this over to somebody doing a presentation for a venture capital firm in terms of investing in their invention or their business or whatever. Or it could just be somebody doing a sales presentation for a committee in a enterprise sale. You talk about opening statements. I know those are so important. So you've done the work. You've found out who the players are. You've researched them. You kind of know their likes, dislikes. You know the questions maybe that you're going to ask. You're going to listen. You're going to. How does an opening statement in the courtroom apply to an opening statement in the sales process?
Once we've picked our jury in the courtroom, counsel then gives an opening statement. It's our version of what the facts and the evidence will show. If you've watched most opening statements, they're not done very well. It's kind of boring. A lot of lawyers just read off of their iPad or their yellow pad. What we do is I'll leave my notes on the table, I'll walk over, and I'll tap and transport my jury back into present day. So if something happened 5 years ago, I'll let them know. Let me take you by the hand and take you back to standing on the corner and then 5 years ago so that they can hear, smell, taste, touch in real time what's happening. That's the first thing I do in the first 2 minutes. So I try to grab their attention. And once I've done that and I've shared my client's story in about 2 to 3 minutes, I'll take a step back. Then I'll introduce my client, maybe introduce opposing counsel, and then roll over to what the facts and evidence is going to show. With respect to venture capitalists, with respect to making a sales pitch, the same process applies. By the time I've given my opening statement, the jury understands what our true why is, and I understand what their true needs are. My true why isn't obtaining money damages for my client. My true why is making sure my client can afford medical care for the rest of his life, can afford, all of the complicated procedures that he or she's going to have to undergo. That's the ultimate why. It just happens to cost money. The jury's job is they need to understand their job is to render a fair and impartial verdict based upon the facts. When you're in front of a venture capital panel, when you're making a sales pitch, figure out what is it they're looking to accomplish here. What are they trying to do? Is it to increase profits by making an investment? Is it to expand their needs into another sector, maybe virtual reality or 3D printing, whatever it might be? What is their real why? And then structure your presentation in a way where you're not wasting your time, you're captivating their attention, but you're talking about satisfying their why with your services and with your products. I think that's the key. It's doing your homework like I watched my mom and dad do back on the Saddle and Surrey Guest Ranch many, many years ago.
Okay, let's go to, wonderful, I love that. Let's go to a couple of comments and questions. Stephanie Newman writes, basically her question is this: what do you do to ensure that you have the best communication between you and your clients? Great question. We haven't really talked about that. Do you have sort of a system there or
From day one, Bob.
Okay.
From day one, it's critically important that the client understand they can tell us anything. And we need them.
And they have to, yeah.
If they want us to be able to do the type of job that we want to do for them, we need to know on day one what's going on. And sometimes it's fed to you, one spoonful at a time over time as the trust between the client and attorney develops. The same thing happens at trial. I'll get a witness on the stand. Bob, if I had you on the stand, chances are for the first 5 or 10 minutes, it's going to be a little structured. You're going to be a little stiff and uncomfortable. I don't know your personality, especially if you're an adverse witness. But once we get into the dance and things start clicking, you understand that I'm not trying to make you look bad. I'm just trying to get to the point. And good things start to happen. I've had adverse witnesses for the other side offer favorable testimony to us because I think they're sitting up there thinking, wow, these guys are actually right, and these guys are trying to pull the wool over our eyes. And when you can make that happen, and it does happen in the real world, it's all because I think you're speaking from your heart. You show you're genuinely interested in the client that you represented, and you respect the system. Let me just share during this whole process, whether you're making a pitch to venture capitalists or I'm in court trying a case, it all comes down to telling a story through facts is critically important, Bob. But for me, even more important, like 10x important, is empowering my jury, empowering the fact maker to be able to decide what I want him or her to do. You can tell the best story in the world, but if you haven't empowered somebody to make a decision, the decision you're looking for me, it's when they leave and go back into the jury deliberation room. If they're not empowered to rule the way I want them to rule, to have that finding, then all of those last 3 years were wasted. The last 2 weeks of jury trial were wasted. So I really focus on empowering the jury and letting them know under our Constitution just how important their role is in the community with being here and hearing the facts of this case. That's key to persuasion.
Wow, inspiring. Thank you. A couple more notes. Then we have just one more question left, and we'll wrap it up. I could talk to you for hours. I wish we could. Mia, she quoted you as kind to people, tough on issues. Love it, she said. Yep, I agree. I love it too. Let's see. There was another one right here, and I think I have lost it because the thingy started going up and down. Again, my technical expertise here. There was one more. There was just a great question. Okay. Let me ask you one more thing, Mitch.
Sure.
The closing. Tell us about that. Everything's done, and you've prepared, and you've created the processes and the environment and so forth. Let's go back to before they get sent empowered back into the jurors' chambers or jurors' room, jury deliberation room. That close. What's the main thing about that you need? Is that where you're empowering? Is that where the close? That the close where you did empower them, or is it more wrapping up the facts of the case?
First of all, I should probably consult with you at some point in the future on this because it's so important. It's like closing a sale, and there's so much to learn. I learn each and every day how to improve everything we're talking about. But yes, the closing argument is where what you want to do is you don't want to spend your time wasting the jury's time going over all the evidence, bit by bit by bit, and that's what a lot of lawyers do. This is where I step in and I try to tap into the emotional element of what they just watched for the last 2 weeks. I want them to be passionate, emotional about what just happened. I want them to feel like they're here to right a wrong, to fix a harm. And the key is we have what are called jury verdict sheets. And I'll actually bring up a big sheet and fill out exactly what I want them to do towards the end of my closing argument. I don't want any misunderstanding as to what my call to action is. And that's really what it is when it's all said and done, because once they get back into that jury deliberation room, it's up to them as to what happens next. We can't talk to them. They can send out questions that the judge can review, and then the attorneys can answer those questions with notes. But you really want to finish your presentation before they leave your presence and go back into the jury deliberation room. And so what I also do, Bob, is I also try to focus on who I think the decision maker is in that jury. Who do I think is going to be the jury foreman? And I usually get it right. It's not that hard to figure out who they're going to select. There's usually a leader in the box. And if it's 2 or 3 people, I'll make sure I make extra eye contact with a jury foreman. When there's a tough decision to make on the case, I'll make sure I'm looking directly at him or her while I'm talking about that issue and why it's so important as a member of our society to be that person back in the room when everyone else says no. And you know that the right answer is yes. You've got to stand up, you've got to stand tall, and you've got to be loud, and you've got to make sure that so-and-so's constitutional rights are followed. It's about empowering the leaders in your audience, on my jury panel, in your sales pitch, to make the right decisions. That's really been a big factor in me getting the results that I'd like for my clients. But I'll tell you, most of my cases are won during jury selection and opening statement. At the end,
it's so funny. I often say
that I'm just bringing it home.
Mitch, it's so funny because I would say that most sales presentations happen during the discovery portion. When you find out through asking questions and listening what that person needs, wants, desires. And it's only after you know that you can match the benefits of your product or service with that. I didn't mean to take the spotlight off of you right there because this is about you. But what you said was so very valuable when you said that it's really won during that initial part. And what so many salespeople think of is, well, if I can only become a great closer, but you become a great closer by being a great opener.
How many times have you watched somebody blow a big deal because they went about the closing process the wrong way? And that's why I like to be emotional and I like to empower my audience. They've heard the evidence. I don't want to waste their time. In today's world, it's hard to keep somebody's attention. The average attention 100 years ago was 20 minutes. Today it's about 9 seconds. The same attention as a goldfish, right? So I want to just share the facts with my jury, tap into their heartstrings, and then give them permission to go back into the deliberation room and just do the right thing. That's what it comes down to.
Well, it's obvious, Mitch, why you are so very successful and have such an amazing presence everywhere that you go. Mitch Jackson is a 2013 California Litigation Lawyer of the Year. And again, he combines law, social media, live streaming to disrupt, hack, improve his clients' companies, causes, and professional relationships. His main website is jacksonandwilson.com. His social media and live video blog is streaming.lawyer.com. And if your company holds conferences and conventions, have Mitch come in to speak. For that, check out streaming.lawyer/speaking. No, streaming.lawyer.com/speaking. And again, all these will be in the comments section. Hey, Mitch, thank you so much. This has been just so great.
Bob, thanks for having me on. My experience in my life has been bettered because our paths have crossed. So thank you very much.
Oh, likewise, my friend and brother. And hey, if you haven't yet gotten the book, The Go-Giver Influencer, John David Mann's and my new book. I'm talking to the audience right now, Mitch, not you. I know you have the book. You go to thegogiver.com and you can check it out there. Also, the Go-Giver Entrepreneurs Academy, Kathy Tajanel's and my next one is in July. We only have 10 people that we have in the event because it's 2 full days. We go through your business completely, totally. And let's see, I think we have 6 or 7 right now, and we haven't started advertising yet. So if this is something you think you might want to attend, go to GoGiverEntrepreneursAcademy.com. I think Shannon's probably putting that in there. It used to be what we called the Go-Giver Sales Academy, but we changed it to Go-Giver Entrepreneurs Academy. And let's see, join our Go-Giver Influencers Facebook page if you haven't thus far, and a lot of great people in there. And no show next week. I'll be in New York doing some promotion for the new book, The Go-Giver Influencer. And but we will be back the following Thursday with another segment and another great guest. So again, on behalf of Mitch Jackson, who's my great friend and a wonderful guest, I'm Bob Burg, wishing you a great day. So long.